Welcome back to the High Court Report, your one-stop shop for Supreme Court coverage. Today we discuss Wolford versus Lopez.
On June 25th, the Supreme Court struck down Hawaii's law requiring licensed gun carriers to get express permission before entering any private business open to the public. Justice Alito wrote for a 6-3 majority. Justice Barrett penned a concurrence. Justices Kagan and Jackson each filed dissents. 5 states ran the same law. This ruling touched all of them.
And the vote breakdown tells only part of the story. The 6-justice majority fractured on some key questions, and we'll get into that.
This was one of 2 huge Second Amendment cases the court decided this term, the other being United States versus Himane.
This was an important case. We were looking forward to it, but the ruling is not ultimately a surprise given how oral arguments played out.
Before we dive deeper, here's your reminder to follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com. All right, here's what you need to know. As you may recall from our preview episode, we called it Hawaii's handgun hurdle, when gun rights meet Mother May Iyaz. Hawaii took a creative approach after the Supreme Court blew up its old gun licensing scheme in Bruin. Right. Bruin, New York State Rifle and Pistol Association versus Bruin, 2022, established that Americans carry a constitutional right to bring handguns in public for self-defense. Hawaii couldn't just ban public carry anymore, so they found a workaround. Here's how property law normally works. When a business opens to the public, a gas station, a coffee shop, a grocery store, centuries of common law imply a license for anyone to enter. Lawyers call it an implied license. The owner's silence means, come on in. Hawaii said, for gun carriers only, silence now means stay out.
And only for gun carriers, not for people with knives, not for solicitors, not for campaign canvassers.
Justice Gorsuch flagged this directly at oral argument. Hawaii flipped the implied license default only with respect to firearms. Not knives, not solicitation, not politicking, nothing else. He wanted to know why that selective targeting didn't automatically signal a Second Amendment problem.
Which it did.
Jason Wolford and 2 other Maui County residents, all licensed carry permit holders, sued to challenge the law and understand what those permits required. Detailed application, medical disclosure, firearms training, live fire shooting, character evaluation. Hawaii vetted them thoroughly, then told them they couldn't enter a dry cleaner without asking permission first.
The majority made the practical stakes concrete. Justice Alito walked through an ordinary day, gas station in the morning, fast food at lunch, drugstore, dry cleaner, grocery store after work. 6 stops, 6 potential criminal violations, just running errands.
The law literally made it a crime to pull into a parking lot while armed, absent a posted sign or a manager's blessing.
So Wolford sued. What happened in the courts?
The district court blocked enforcement of the law as applied to businesses open to the public. The Ninth Circuit reversed and upheld Hawaii's law. The full Ninth Circuit refused to rehear the case, but 6 Ninth Circuit judges dissented from that refusal. Judge Van Dyke calculated that Hawaii's combined web of laws prohibited carry on 96.4% of publicly accessible land in Maui County.
Essentially everywhere. The Supreme Court took the case.
Arguments ran January 20th, 2026, Alan Beck for the permit holders, Sarah Harris for the United States supporting them, Neil Katyal for Hawaii.
And you could hear where the court headed during argument. Justice Kavanaugh cut straight to it. No deeply rooted historical tradition, no broad support across states, just insufficient analogues.
Pretty simple case, he said. Harris agreed.
Now here's the legal framework. The test comes from Bruin. 2 steps. First, does the challenge law restrict what the Second Amendment's plain text covers? Second, does history and tradition justify the restriction? Step 1, yes. Step 2, no. The law falls.
Step 1 seemed almost automatic here. The permit holders sought to carry, meaning bear in Second Amendment terms, arms, meaning handguns, in public. The law fell within the plain text, presumptively unconstitutional. Hawaii then needed to carry Step 2.
And they tried. 3 buckets of historical analogues. Bucket 1, Colonial anti-poaching laws. A 1721 Pennsylvania statute, 1722 New Jersey law, 1728 Maryland statute, 1763 New York law, 1771 New Jersey law. All prohibited bringing guns onto someone else's land without permission, specifically to stop unauthorized hunting.
The court distinguished those. Bruin requires asking how and why a historical law restricted the right. Those anti-poaching laws targeted specific concrete harms. Poachers stole game, trampled crops, fired guns near livestock, injured bystanders. They applied to agricultural land. A permit holder quietly entering a Starbucks doesn't produce any of that.
At oral argument, Harris sharpened the point further. Those anti-poaching laws actually showed the opposite tradition from what Hawaii claimed. Property open to the public carried a default of free armed entry at the founding. Only enclosed farmland required permission. Hawaii flipped exactly that historical baseline.
Justice Alito's line in the opinion, "The question answers itself."
Bucket 2. An 1893 Oregon law prohibiting armed trespass on enclosed premises. Oregon courts read enclosed as outdoor fenced farmland, not commercial storefronts. One lone statute from a century after the Second Amendment carries almost no weight.
And bucket 3?
An 1865 Louisiana statute, part of Louisiana's post-Civil War black codes, prohibiting firearm carry on another person's premises without consent.
That's a remarkable choice of analog.
Justice Gorsuch put it directly to Harris. Did Hawaii uncover a historical dead ringer in the black codes? She called it, pulling from the oral argument transcript, somewhat astonishing that these laws would surface in 2026 as evidence of permissible firearm tradition.
And the majority agreed. Louisiana's 1865 Black Code aimed to re-subordinate newly freed Black Americans, cut off their ability to hunt and forage, push them back onto plantation labor, leave them defenseless. The Republicans who drafted the 14th Amendment understood the right to keep and bear arms as critical to Black Americans' safety during exactly this period.
The court held Hawaii's reliance on that statute defied serious consideration, then reversed the Ninth Circuit 6-3.
Now, here's where it gets genuinely interesting. The fractures inside that six-justice majority. Chief Justice Roberts and Justice Kavanaugh signed onto Alito's majority and stopped there. No separate writing. They took the straightforward path. No historical analogues, law falls.
But Justices Barrett, Thomas, and Gorsuch went further, and they didn't all go the same direction. Barrett filed a concurrence joining the majority completely, but writing separately to address two specific fights. Thomas and Gorsuch joined one part of her concurrence, Part 2, B, but not the other.
So they split from Barrett on something.
Barrett wrote two parts. Part 1 addressed why Hawaii's "this case lives in property law, not the Second Amendment" argument fails. Part 2, B, addressed why the black codes can't justify Hawaii's law. Thomas and Gorsuch joined only Part 2B.
They agreed with Barrett on the black codes, but didn't commit to her reasoning about Step 1.
Exactly. And that gap matters. Barrett's Part 1 made a specific methodological claim. At Bruin's first step, history only clarifies what textual phrases mean, like what bear arms means. It doesn't establish what the pre-existing limits of the right stood at the founding. Thomas and Gorsuch left that argument without their endorsement.
And Jackson's dissent argued the exact opposite. That history absolutely belongs at Step 1 because the Second Amendment codified a pre-existing right. And understanding the limits baked into that pre-existing right requires consulting history. Barrett and Jackson fought this out directly in their respective opinions.
A genuine methodological debate happening inside the formal opinions, and no majority resolution.
Which means a future court can't count on 5 votes for Barrett's approach to Step 1.
And on the dissenting side, 3 justices dissented but didn't present a unified front.
Kagan dissented alone. Jackson and Sotomayor dissented together. Kagan's dissent ran 1.5 pages. Jackson's ran nearly 30.
Kagan went narrow. She argued for upholding Hawaii's law based purely on the historical analogues. She read the anti-poaching laws as close enough in principle to support Hawaii's rule. No engagement with the Step 1 question. No engagement with the Black Code issue. Clean, contained dissent.
Jackson swung for the fences. She attacked the majority at every level. The Step 1 methodology, the analog analysis, and the Black Code exclusion. She called the majority's version of Bruin a fig leaf that gives courts cover to strike down gun regulation whenever they choose.
Why didn't Kagan join Jackson?
Probably because Kagan saw value in staying narrow. A dissent grounded purely in historical analogues leaves more room in future cases. It doesn't require calling the entire Bruin framework illegitimate, which Jackson effectively did.
Jackson's central argument was that this case never implicated the Second Amendment in the first place. Everyone agreed, including the permit holders themselves, that a property owner can exclude armed visitors. The only dispute involved the form of consent, implied or express. Jackson argued that question belongs entirely to state property law.
At oral argument, she pressed this repeatedly. In a world where the Second Amendment already yields to the property owner's actual decision to exclude, what constitutional right suffers when a state says that decision must arrive expressly rather than flow from silence?
Harris's best answer, flipping silence means permission to silence means prohibition, effectively bans public carry without calling it a ban. Most owners never post signs either way. Under Hawaii's rule, that silence bars gun carriers from entering everywhere.
Jackson also raised what I'd call the hardest unresolved question in the whole opinion. What courts do with historically tainted laws under Bruin?
The Black Code exclusion. Jackson argued the majority couldn't discard an entire category of historical laws without a principled framework. If history determines constitutional meaning, courts must engage with all of it, including the painful parts.
She pressed this at argument, too. Those laws didn't carry a judicial stamp of unconstitutionality when enacted. They reflected what legislatures actually did. Does their later unconstitutionality retroactively erase them from the historical record?
The majority said yes. Unconstitutional laws count as outliers from inception. Jackson said that's circular. You can't use your conclusion to curate the evidence.
And she raised a fair point. The court needs a principled rule for this, and it didn't provide one. That question remains open.
All right, let's talk about what this actually means. This case feels like a sneaky strong ruling, especially given that it's a constitutional case, Second Amendment. It necessarily restricts the types of laws states can pass.
For permit holders in Hawaii, California, Maryland, New Jersey, and New York, the 5 states that ran opt-in consent regimes, the default just flipped back. Those state laws crumble. Licensed carriers may now enter private commercial property while armed unless the owner specifically says no.
Property owners keep full authority to post no firearms signs or directly exclude armed visitors. The burden just shifted. Silence now means permission, not prohibition.
For businesses in those states, signage now matters. Want to keep armed customers out? Post a sign. That responsibility now falls on you, not on the customer to find you and ask.
For the broader Second Amendment landscape, the court tightened the historical analog standards significantly. Scattered colonial hunting laws don't justify broad restrictions on commercial carry.
The black codes don't count. One lone outlier statute from the 1890s doesn't move the needle.
What stays open?
The residential question, can states require opt-in consent for private homes? The court explicitly declined to decide that. Justice Barrett's hypothetical also left open whether a narrower, crime-specific consent rule targeting a particular venue type might survive. And Jackson's unresolved critique about filtering the historical record will drive future litigation. The Barrett concurrence, even with Thomas and Gorsuch joining only part of it, signals that real methodological debates about Bruin remain live at this court. More Second Amendment cases are coming.
Bottom line?
Hawaii told licensed gun carriers, ask, "Mother, may I?" before entering a gas station. The Supreme Court told Hawaii the Second Amendment doesn't allow that. And 5 other states got the same message.
6-3.
And the fractures in that 6 don't weaken the result. But they preview fights this court will return to.
Stay tuned.
Thanks for listening to today's High Court Report episode. Remember, please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com.
Talk to you soon.